All right, good afternoon, everyone. This is Jeff with Citizens Media TV, and I'm here with Bill Brennan. And Bill, we are about to go into what seems to be the final day of the hearing for David Samson, probable cause hearing. So why don't you give us a preview?
Well, just to recap, a couple of weeks ago back, we came in on my complaint, and normally what happens in the municipal court is you swear out a complaint at a window downstairs, and the administrator there can determine probable cause on the spot. Because of the nature of the charge, because of the defendants involved, they decided to send it up here for a hearing. We had a hearing, and Mr. Sampson sent the law firm to represent him, and they're raising all manner of arguments that are inappropriate at this point in the proceedings. They're trying to get this case dismissed before it's even been filed, and that's inappropriate. Now, I responded to their letter. I opposed it last night, and one of the things I opposed was forcing me as a citizen complainant to engage in complicated legal argument with high-powered law firms. This is, again, part of the parcel of the problem that we have, where there's two systems of justice. One system of justice where a regular citizen can have probable cause determined by a clerk at a window, and another system of justice where a real wealthy, powerful, former Attorney General, former Chairman of the Port Authority can have 3 days of hearings stretched out over a month dealing with complicated and convoluted legal arguments. The only issue before this judge is there probable cause to believe that Chris Christie committed an act of official misconduct, and if so, did the complaint get brought within the statute of limitations? David Sampson. I'm sorry, did David Sampson commit an act of official misconduct, and if so, did that act of official misconduct occur within the 7-year statute of limitations? Every other argument that's being raised is a smokescreen designed to try and bully the court into doing something it's not supposed to.
I'd like to, probable cause and lawyers coming in before the hearing even starts. I think an easier analogy for the general public is it's like telling an officer that he's not allowed to arrest somebody. Because isn't that also determining probable cause on the spot? And that you don't bring a lawyer in to tell a cop you can't even arrest him before the trial.
You're exactly right. If a police officer witnesses a crime in the street, he makes an arrest, he finds probable cause for the arrest, and he makes the arrest right now. And another example would be at a grand jury. You don't get to cross-examine witnesses at a grand jury. All a grand jury determines in order to indict is whether or not probable cause exists and whether or not it's within the statute of limitations. Those are the two questions for a grand jury to answer. Those are the two questions for this judge to answer. Those are the two questions for a cop to answer, and the cop can even get it wrong on statute of limitations. As long as he has sufficient evidence to believe that the official misconduct occurred or the crime occurred that he's arresting for, he makes the arrest and probable cause is determined. This is a system that's being set up for one wealthy man who can.
Is it true you said you start off your legal brief with the wealthiest and most powerful person to ever go before this judge?
Yes, Judge Adamas has never seen a defendant as wealthy and powerful as David Sampson in this courtroom.
Okay. Why don't you give us an overview of I think there's basically 3 major arguments that they're trying to make, and what are your, how to go back against those?
Yeah, they're saying that a citizen doesn't have the right to bring a complaint for anything other than a minor violation, and that's just wrong. The Rule 7:2-2A says specifically, a citizen may bring a complaint on any matter. Any matter is not a term of limitation. And I was able to present the transcript of Judge McGeady and his decision in denying that same argument to Chris Christie last November. And he was upheld in every way on that issue. The second thing that they're trying to say is that I have no standing as a citizen to bring a complaint against something that I lack personal knowledge about. Well, Judge McGeady also refuted that.
That's a very easy way of protecting yourself against anything, because your people won't prosecute you. So.
Right, and again, the whole citizen complaint statute was set up for purposes of things like this. And the evidence that I have is competent evidence. It's not even hearsay, and hearsay is admissible. In this case, the evidence against David Sampson is his own confession. And his own confession is not hearsay. It's not even an exception to the hearsay rule. It is a public record. It's again, they're arguing as species.
So, I understand that their argument is that, or one of their arguments is that these actions that he did were already prosecuted. But that's not the law. This is what you say is that, elaborate on it.
Well, they're making a double jeopardy argument. And as we argued last time, the double jeopardy doesn't apply here for a number of reasons. The state of New Jersey is a separate sovereign from the United States government. So the two separate sovereigns automatically double jeopardy doesn't apply. But not only that, This man pled guilty to bribery and extortion, and I'm charging him with official misconduct. You don't need to commit bribery or extortion to engage in official misconduct, and you don't need to commit official misconduct in order to engage in bribery and extortion. They relied upon a statute that says when there's a preclusive effect, when a state law prosecution would be precluded by a federal law prosecution. And they're very strong in that argument up to the point where it says unless. And the unless portion of that statute is very clear. Unless the elements of the offense are different or the facts underlying the offense are different. And in this case, the elements of official misconduct, one of them is you must be a public official. You don't have to be a public official to be arrested for bribery and extortion. In fact, Jamie Foxx, who was the United Airlines representative who transmitted the bribe and transmitted the extortion threat and the bribe and arranged for it, he was not a public official. He was an executive at United Airlines. United Airlines paid a major fine for doing this as well. So again, you don't have to be a public official to engage in bribery and extortion, and you don't have to engage in bribery and extortion to be guilty of official misconduct.
And you call official misconduct a more pernicious evil than bribery?
Yes, thank you for reminding me that. The unless the evil or harm to be prevented is substantially different or greater than the one originally prosecuted. And official misconduct is indeed a more pernicious evil than bribery and extortion. Bribery and extortion can go on generally. The mafia does it with carding contracts, and you will either pay me off and we will allow you to operate in our territory, etc. No public official gets involved in that, bribery and extortion. Now, when you get a public official abusing his authority, it is a far more dangerous proposition than having a criminal abuse his authority, because the power of the government is the most powerful weapon on the planet right now. And the government of New Jersey, the government of the United States, is being turned against innocent citizens, and that is a pernicious evil that needs to be put down.
Okay, let me ask you a devil's advocate and an ignorance question, which is, he was already tried for these actions, which is not legally binding, but he was tried for the actions, and now there's a different crime, a different way of looking at those same actions, because as a public official as opposed to an individual who committed bribery and extortion. Is there a way, what they're sort of implying is that double jeopardy is taking a situation and looking at it from, you can find different ways of saying that there was different kinds of crimes on the same action over and over and over again. Is there a way of abusing that kind of, taking a single action and saying that there was many different crimes committed in different perspectives?
Well, let me put it in perspective so that more easily understood. You're a lot younger than me, but back in the 90s when Rodney King was beaten by the police, the officers, I think it was Stacey Coons and another officer who were tried on that case, they were exonerated by a jury. They were found not guilty. For those same actions, the United States of America, the U.S. Attorney for the Southern District, for Southern California, I think it was in the Ninth Circuit, he charged them for those same actions with civil rights violations against Rodney King, and they all went to jail. Now, nobody complained that the federal government was abusing the rights of those police officers. I don't see how you can say that this man's rights are being abused, because again, his actions are different. Extorting a bribe and accepting a bribe are different than pulling something from the calendar, which was, again, in the email events, he said in his email, I pulled it off the calendar. Now, that was neither bribery nor extortion. That was retaliation for not complying with the extortion threat. That was following through. That was merely an abuse of authority that was regardless of the bribery and extortion. It was he merely abused his authority to take something off the calendar, off the public agenda, and avoid having that aircraft hangar voted on. Because remember, that's what this is about. United Airlines needed a multi-million-dollar hangar where they could repair their aircraft at one of their major hubs in Newark, New Jersey, and it was part and parcel of an efficient airline operation. They needed it. He knew they needed it, and he held up that approval to get that unless and until they gave him what he wanted. And when they didn't give him what he wanted, he literally took it off the agenda and didn't allow a vote.
Yeah, so I think the answer is that the bribery and extortion is a very narrow view of this crime. And this is a much more broad view of the same crime. So it's like a subset almost. So,
yeah, what he did was he engaged in a pattern of official misconduct, and that can be added as a charge to this charge once the prosecutor takes over. What they are trying to do is have this taken out of the hands of the prosecutor by the judge. They essentially want the judge to do the dirty work of the defense, and that is not the judge's function, to engage in the dirty work of dismissing a valid complaint. And I don't think this judge is going to do that. I think he's going to find probable cause, and it'll go into the hands of an Essex County prosecutor, who's an acting Essex County prosecutor, who was appointed by Chris Christie.
So if he does choose declare probable cause, it is likely that this will go much farther than the Christie one went because he assigns his own prosecutors.
Well, Christie assigned this prosecutor too, but Christie will protect David Sampson any way he can. The problem that they have once this goes to the Essex County prosecutor is Bergen County was able to say, as absurd as it sounds, they couldn't get a conviction beyond a reasonable doubt, so they administratively dismissed the charge against Chris Christie. Essex County can't make that specious argument because in this case, what Sampson confessed to and allocated to and pled guilty to satisfies every element of official misconduct. There's not even a need for a trial. And remember something, none of the arguments made by David Sampson's attorney include an allegation or a contention that he's innocent of the charge. He's all but stipulated his guilt here. So he can't get a prosecutor to say we wouldn't be able to get a conviction beyond a reasonable doubt under these circumstances because he stood in court and said, I demanded this, when I didn't get that, I did this, and I extorted this in exchange for that. That's official misconduct in anybody's book, and he's going to have to go to jail or cooperate in a case against Chris Christie, which I'd be willing to make arrangements for if he's willing to do so.
So you had some concerns of just simply the time between last hearing and now of pressure being put on the judge. So what are your concerns like that and other concerns that you do have? I mean, yes, if there's justice, they'll find probable cause, is what you're saying. But sometimes there's no justice, especially if someone's so powerful.
Yeah, these people have proven time and time again that they're open and notorious and brazen about what they'll do. They will promise, or they will threaten, or they'll promise and they will threaten to take action or withhold action against somebody. And this judge here is put in a position, he signed up to be a judge, he's put in a position where he's going to have to do what's right despite enormous pressure being placed upon him to do something other than what's right. And we'll see what he's made of, but I've got faith in him.
Okay. All right.
Thanks,
you.
Jeff.
All right.
Always a pleasure.
All right. We'll be in the trial, and we'll be filming, and we'll tell you what happens afterwards. Thanks. I don't know why. I'm about to press the button, but you're holding.
If you'll place your appearances on the record.
Your Honor, for David Samson, Angelo Genova Burners, Newark, New Jersey.
Anthony Anastasio, also for Mr. Sampson, also of Genova Burners.
Okay. So you don't necessarily need to place your name on the record, Mr. It's formally William Brennan, but
Yes.
Bill is what you've also been referred to or placed on the record, I believe, as well in the past or written down. So you're, just to kind of go back, because we've had some gaps in time, and I said to the staff just a moment ago, I was waiting for my son's spring break, as you know, and as we discussed before, and the temperature was like in the 90s, and I come back here, I'm freezing, so I'm freezing cold. I don't know if you're cold down there, but I'll try my best to make this as quick as possible so we can get out and get on with our days. Where we are is simply this. This is a probable cause determination. So I wanted to redefine some things. I've received documents that you both provided to me, reviewed those quickly in the last few days that I did receive them. Thank you both for giving me the opportunity to have some time on vacation before receiving those things. But I quickly read through all of that stuff and did my own research, and want to make this as simple as possible. So I'll speak hopefully for the most part in just very simple layman terms so that it's well understood my position. Certainly my position is one that's both in agreement with each of you in some regards, and I also disagree with both of you in some regards. So I tend to, when it comes to these type of matters, speak with examples. And so I'm going to use some examples at this particular time to kind of just round out not where we are, but where we should have been. So I made mention in the past of a person, whether it's a gentleman or a lady who's selling some ice cream on the street. If someone stole some money from that individual, whether it was directly from the person or from the area, whether it was a robbery or a theft, that person would do one of two things. If it was a minor matter, a person can come to room 207 like you did, Mr. Brennan, and file a complaint, generally, say for instance it's a theft offense, $3 I think I had mentioned in this little scenario I talked about in the past. That person would do just as you do. Go to room 207, speak with one of the deputy court administrator, and fill out a form, which you did, Mr. Brennan. Take an oath or something to that effect, and describe then what took place and what have you, and that person will make a determination if probable cause exists. Not if the person is guilty, not if the person is guilty beyond a reasonable doubt, simply that there's enough to have the case move forward in the system, right? It's a probable cause determination. So I think I was trying to make it clear, but I'm going to make it more clear today, what it is that we're actually doing. So this is a hearing in many matters, just like all of the other matters that were here before me, as you saw people walking in the room here and on the video. Those were all hearings, but there's two forms of probable cause that I want to clarify, so we're on the same page. A probable cause hearing tends to be one that is done after the person has been accused, after a probable cause determination has been found, and then there's a hearing. Oftentimes, I had mentioned previously, an attorney would say, Judge, now an attorney comes into the case and would say, Judge, I want to have a probable cause hearing. And normally I would have arraigned the person, entered a not guilty plea, put the date on the matter, taken the attorney's appearance, and said, okay, you want to have a probable cause hearing? I would need the complaining witness present, and the complaining witness then would be placed on the oath, and I would ask questions of them. The attorney sometimes would want to ask some questions, but if I allowed that, would do so in a very limited way, because it's not a full-blown trial. It's just a time where I take some information to make a determination if, in fact, probable cause did exist. When a court administrator or deputy court administrator is taking probable cause at the window, they may not have all the facts and circumstances that the case would see later on in the process. So what this is not a probable cause hearing under those definitions. This is a probable cause determination. So a probable cause determination happens rather quickly. When I say rather quickly, it's not weeks like we've been doing. It's not days necessarily. It's minutes, it's minutes, really minutes. And so I'm going to use some examples to describe the probable cause determination from various angles in our system. So based on my experience, that same ice cream vendor, he or she could come to room 207 and speak with our deputy court administrator. Within minutes, the deputy court administrator could determine if there was probable cause and schedule the case to go forward. The person can be seen by a judge, and in some jurisdictions, that's what happens. It's seen by a judge. I already explained to you, Mr. Brennan, I believe counsel explained to him. Sometimes matters come to me when it's a little more sticky for whatever reason, and I do this, maybe a few times a week. I make a determination. I explain that I'm the supervising criminal judge, So the matters are kicked to me and I deal with them. So I would do very much like a deputy court administrator, or court administrator. I would place a person under oath, like I did with you, Mr. Brennan. I would take some information, I would ask some questions. I started to do those things with you. You wanted to give me some paperwork to look over. I needed some background. You're supporting documentation. And so I needed at least some time to go over that. Procedural history should reflect that that was a Tuesday. The Wednesday, the day after, I had a bunch of weddings to do in the afternoon. So I didn't have the time to do the hearing. I was responsible to do the weddings that day, so I scheduled it for Thursday. The media put information out, and it's my understanding that Mr. Samson became aware of these terminations being had, and Mr. Genova was then involved in this case. So last time I spoke with both of you, I had made mention too that as a courtesy, I was having you sit here, Mr. Brennan, because this is not the norm. And counsel, the same thing, because first question I had was whether there was any justification for having counsel attack at this time. So we'll address that shortly. But the ice cream vendor also has the opportunity to go to the police station. If the vendor goes to the police station and the officer believes there's enough proof at that particular time or after a short investigation that a crime or offense was committed, did exist, the officer would make a determination to do one of two things. Either place the matter on a summons complaint and then find probable cause on his or her own. Officer can do that. Police officer can do that. If the officer makes a determination that they want to put it on a warrant complaint, which has more severe consequences, that means that the person can then be arrested. In the past, a year ago, bail could have been set under the new bail system as of January 1st. If a warrant is signed, probable cause is found then, the person's just detained. There's no bail. The person's detained, for the most part. So the officer on the ice cream vendor matter can make determination that there's probable cause, and that's done rather quickly after some information is there. If the officer wants the warrant complaint, the officer calls a judge, like myself. Nowadays, they indicate that there's something in the queue. I would look at my tablet, I would find the matter, I would read over what is now called the affidavit of probable cause, which set forth the purpose for the complaint. Generally, it's satisfactory for probable cause purposes. I click on probable cause found. I look if the person's in fact picked up, if that person's in police custody. There's some additional information that comes up in the system that would kind of show me the person's background history, criminal history. I review that, then I have a determination to place it on a summons complaint or a warrant complaint. If I put it on a warrant complaint, the person is detained without a bail. All of that stuff is done rather quickly. If I received a call right now from an officer or detective telling me that there was something in the queue and I had nothing else going on, I had my tablet there by my side, I could go on the tablet, should the network be working well, pull it up within moments, take a few minutes to read the affidavit of probable cause, which is generally a page or less. They can't go over a page in the system. And so it has to set forth all of the circumstances. I can read that rather quickly, make sure everything is there, like my check-off list, in my mind that is. I then look at the person's criminal history if that is in the system. If I make a determination to put on a warrant, I do that, I hit submit. I can have that all done in 5 minutes. Probable cause determination, 5 minutes. Police officer can do the same thing. I mean, it take a little longer to type all the paperwork and all that stuff like that. Court administrator, deputy court administrator can do that, all in a short period of time. They can make that determination quick. So the thing that we're doing right now is not a hearing per se, it's actually still a probable cause determination. Mr. Brennan, I would have been prepared to render a decision whether there was probable cause or no probable cause on that Tuesday. I could have done that. Had it been early in the day and I said, just give me 30 minutes or something just to read through this stuff and verify some things, we could have did it then, Now, we would have also gone through that checklist that I keep in my mind to make sure that everything is there. And I had pointed out some of those things previously. I got to make sure there's a name there that's appropriate. Sometimes individuals come in, I said this before, they say, oh, it's Mr. Rivera. Who's Mr. Rivera? It's got to be more than that. I know that he's, over there on this street. No, you got to be more specific in terms of the address because we have to send out notice and what have you. So you have to be more specific with it. With a name, an address. You can't tell me it happened sometime in 2016. It has to be more specific. So there has to be this basic checklist in many ways that I have to go through. And I have to also see that the statute and the offense as listed in the narrative, they match. And I have to make sure that, in fact, it seems as though the elements are there as well. So there's a number of little things that I have to do. And over the course of years, I've learned to do this kind of automatic. Just kind of look, I kind of know what to look for. I see, okay, good, probable cause, I can make that determination. But there's other factors that I keep in my mind as well. So I was interested in some of the arguments made last time we were together, some things that I should consider as well in this, what we call determination. Now, or what I call determination. There's some things that are mentioned in Mr. Nova's brief relating to me dismissing the complaint. I can't dismiss a complaint at this particular stage because it's not even issued at this point. Once the matter is issued, where I found probable cause, then the matter can be dismissed, at that point. But if I determine that there's no probable cause, I don't even dismiss it. I just write no probable cause, and that's just entered into the system. It's not a dismissal at that point. So I just wanted to speak clearly and try to clarify where we are today and what type of things happen during the determination and how simple and basic they can be. So I don't want to speak, and I know Mr. Brennan, you indicated you were a graduate here at the Law School Seton Hall, and legalese are things that you're very familiar with, and you've done very, very well for yourself as a layperson, coming before the court and making certain arguments. Very impressed. You're looking at statutes on your cell phone at the time that they're being argued by counsel, and you're making objections, and you're not formal objections, but you're arguing against them and how they apply or not apply, and that's impressive. But at this particular stage, I want to still treat you as the complaining witness that you are, and I want to point out some things that concern me on both ends. Okay. So I started to make mention about something simple, that a complaint at this particular point cannot be dismissed. The argument could be that I determined that there's no probable cause, but after I sign this and determine that there's probable cause, that then triggers the possibility for a hearing, and there could be a more extensive hearing related to whether there is in fact probable cause, more proofs can be developed at that time. Not a trial, but a little more extensive than the determination factor. So another thought that I want to point out is that I had some concern when counsel attached. And so when does the right to counsel attach? Certainly I'm clear, and I'm more than comfortable to say that once a person has been charged by the authorities, by police, by the prosecutors. A complaint has been entered and filed against them in our courts. The person now has been accused of an offense or crime, and the laws are clear and say that the person then has rights to counsel. And at that point, again, the attorney can make mention to have a request to have a probable cause hearing. So, because this is a determination still, my argument, or I should say my request of you, counsel, was to persuade me that in fact you should be sitting here at this time. Mr. Brennan made mention that I shouldn't set precedent, something to that effect, and allow you to sit here at this time because this is not the appropriate time. The appropriate time would be after I determined probable cause existed, after I signed the complaint, after it's been entered into the system. Now your client would be someone who's accused, and then certainly the right to counsel attached. I'll give you an opportunity. I'll give you both an opportunity.
My question was, does Your Honor wish me to address that as a threshold?
Momentarily. Because I first described the various ways, just a few of them actually, there's not many of them, that outside of the prosecutor can, whether it's the federal prosecutor, one of the county prosecutors, can bring forth investigation on their own and take matters to the grand jury. But I was just talking in more simple ways where a judge interacts with a document like this. And that's, after police find probable cause, after Room 207 finds probable cause, in this instance Room 207 being Newark Municipal Court, whether someone comes up to my courtroom and I determine that there's probable cause, or whether an officer calls me asking for a warrant complaint to be signed and I determine probable cause. Those are done real quick. I do those matters quickly. I just described 5 minutes on this tablet. I already determine probable cause, so long as all the information is there that I need. And judges all around the state are doing the same thing with their computers and tablets and phones. They're making determinations very quickly. Now, at that particular time, there is no attorney that is present. When an officer's calling me for a warrant complaint and it's 3 o'clock in the morning, there's no attorney that even may be familiar or aware that their client is being charged. So this is something that's not done with an attorney, defense attorney present, with a judge determining, based on arguments from an attorney like yourself, Mr. Genova, whether probable cause should even be, found. So I'm still, and I'll allow you to make an argument, still concerned that the right to counsel does not exist yet. It doesn't exist now in a determination factor, these factors. So you do want to be heard. I give you the opportunity to answer.
Why is it that counsel sought to be heard in this case? It's because when Mr. Brennan went to room 207, he let the world know, and you allowed in his courtroom a camera that he put on the internet disclosing that he, as a citizen, decided to be a private prosecutor against my client. Your Honor's right, this is unusual. It's highly unusual. It's highly irregular. And it starts with what Mr. Brennan's motives are and whether he wants to manipulate room 207 or he wants to manipulate this process towards an end to achieve a personal advantage, whatever that might be. It starts with that. I'll concur with Your Honor. We are in a very unusual place. And as Your Honor described the process, you're correct. But your role is not merely ministerial. You may have the capacity in those court administrators in room 207 and that cop on the beat to make certain judgments quickly, as you put it. But it's not a ministerial function. And let's start with what the Supreme Court told us. Because respectfully, Your Honor, I think the Supreme Court of the United States has spoken exactly to the point of whether I have a right to be here today on behalf of Mr. Sampson. And we cited to you Coleman versus Alabama in our brief. And that cites a case we all learned in school, law school, Powell versus Alabama. And it cites United States versus Wade. And let me read two excerpts for you. The first is citing United States versus Wade. It is central to that principle of the right to counsel, that in addition to counsel's presence at trial, the accused is guaranteed that he not stand alone against the state at any stage of the prosecution, formal or informal. I'll pause. Formal or informal. In court or out, where counsel's absence might derogate from the accused's right to a fair trial. Then it goes on. Whether substantial prejudice to defendant's rights inheres in the confrontation and the ability of counsel to help avoid that prejudice. That necessarily dovetails with what's happening here. Your Honor, I will buy your paradigm. I would agree with you that it's not a hearing in the sense of witness cross-examinations and the like. It is a determination that you have the authority to render and you have authority to decline. You have the discretion to decline that finding. But we're here at the inception where Mr. Brennan seeks to invoke a statute that allows for citizen complaints by piggybacking on what? A federal prosecution that's already occurred, a federal conviction that's already occurred, a sentence that's imposed on my client. Bootstrapping on all of those, duplicating and relying exclusively on the information that was filed in that case and the judgment of conviction. And once this court, and to utilize this court to make a probable cause determination that clearly invites a double jeopardy, clearly invites a violation of a statute that talks about successive prosecutions. Now, all of this starts with the idea that because your role is more than ministerial, it starts with the notion, and we cite the cases to you, Your Honor, whether it starts with Lloydman that tells us that private prosecutions are disfavored in this state. This is a private prosecution, bootstrapping on a federal prosecution that's already taken place and notorious in this state. Notorious. We all know it's notorious. I think we cited there were thousands of articles about the prosecution of Mr. Sampson. Do you think there's one prosecutor, whether it's the Newark Municipal Prosecutor, the Essex County Prosecutor, the Attorney General of New Jersey, that doesn't know the facts of this case? Yet along come Mr. Brennan, candidate for office of Governor of New Jersey in the Democratic primary. And all of a sudden, the bell goes off. This private citizen thinks there should be a private prosecution. Is that what that statute was intended to do? I think not, Your Honor. I think not. What I think is this is the very circumstance that a body tells us, that Lloydman tells us, that the court's inherent sense of fairness on the propriety of the misuse and abuse of that system has to be abated. And it's in this determination that you should abate it. Let there be no question about it. You should exercise your authority. Whether you want to call it a dismissal or complaint, we call it that because that's what Mr. Brennan filed. But if you want to call it a finding of no probable cause, that there should be no determination, be my guest, but that's what should happen here. There's no doubt that that should happen here, or that should not happen here. So we start with the idea, Your Honor, that there is an element of fairness in the application of our criminal laws. I think that's unrebuttable. I think that's part and parcel of what you're supposed to be doing. Just like the lady with the ice cream cone that was taken away, if that end went up to your desk, you would have the inherent authority and you would have the obligation to begin to address whether or not the citizen complaint is in the interest of justice. When you move beyond the standing issue, which we think is eminently clear from Coleman and eminently clear from State versus Dennis, we are in a place where there has been an effort to invoke the criminal justice system. The minute Mr. Brennan walked into room 207, he invoked it. It was an invitation under the statute, but he invoked it. And to say that, well, that's a place that doesn't have the potential to denigrate the reputation and other rights of my client, when in fact, we all read about it on the newspaper the next day, Mr. Brennan showed up in room 207, I think is a mischaracterization. That invocation and this process denigrates the rights and interests of my client, when in fact, it should never get beyond first base for all the reasons we've mentioned.
So,
Now, if I might finish, Your Honor.
okay. Have some questions.
I'll go to Your Honor, I'm
Okay,
sorry.
so, and I appreciate your arguments. Where we are, as you say, is a very uncommon, rare, unique place. I still believe that all of the arguments that you cited here and cited in your documentation, both the last packet and the first, really are more appropriate for after a probable cause finding signature accusation is true.
I guess, Your Honor, if I might just ask the bench and the court, you are about to, am I to take it that Your Honor then views your function as ministerial? That to the extent, if you disagree that we have standing, then you're right. I don't concede you're right, but if you disagree that we don't have standing, then you never get to hear these. But to the extent that we have standing, and you get to hear these, and you have the inherent authority to exercise functional fairness in the prosecution, in the processing of the criminal justice process, then this idea, well, you'll get to argue those later, but the damage is done, Your Honor. The damage is done when you permit, the invocation of the statute, and when you permit that the citizen complaint to pursue in a jurisdiction where those complaints are disfavored. You permit that to happen simply because you exercise what you might have characterized as a ministerial function, that, well, that's the way it's always done. What it isn't always done is we don't always have cameras in the courtroom and a probable cause determination. What isn't always done is we always don't have a political campaign in which this process and this courtroom is being leveraged for YouTubes the minute we walk out of the courtroom. Those things we don't have, Your Honor. Those things we don't have when the lady with the ice cream cone shows up in room 207.
The ice cream vendor there, if I can, continue the example, right? Let's say, for instance, she did go down to room 207 and say some monies had been taken from her. Now, room 207, court administrator, deputy court administrator, and so again, room 207 is just simply the office for the criminal division, and there's windows there, and that's where complaints are taken in this courtroom, North Municipal Court. So in that particular place where the court administrators, deputy court administrators work, they could make a determination, and certainly that's the way it's been, because that's the way it's been set in the court rules and what have you. That all complaints should be taken. Doesn't mean that probable cause has to be found. But a court administrator or deputy court administrator can't see a person walking up and say, listen, I'm not taking your complaint today. I'm exhausted. They can't do that.
Precisely.
They have to take the complaint. Now, they have to determine one of two things. Probable cause found, probable cause not found. They make those determinations. They find probable cause, the matter goes forward. Then, as I say again, I see the briefs, I hear the arguments, we have a hearing after the person has been accused, right? And so, again, we're in this very unique place because, and I don't want to set any new precedent or say, you know, because the reality is this, there's no attorneys sitting at the police station waiting for some clients, potential clients to walk in with cuffs and then trying to make arguments to the officer why there should not be probable cause determined. And so that doesn't happen. That doesn't happen. So had Mr. Brennan, for instance, gone over to the police station, brought whatever proofs that the officers would accept, and they did their, you know, due diligence, whatever that might be, they could have determined that probable cause existed and placed it on a summons without any judicial intervention. I wouldn't get a call at all. But if those officers made a determination that it should be put on a warrant, they'll call me, I'll look on my tablet, I'll make some determinations. No defense attorneys at that point. All happens rather quickly, right? All happens rather quickly. And so this is unique because it comes before me. And it's unique because, as you said, it kind of went out there into the universe, this information. You said YouTube or, you know, through the media. I don't know which way it went, out into the public, but somehow Mr. Sampson was informed and retained you. So during the determination, I never, ever, ever have had an attorney involved. During the determination, never, ever, ever had the prosecutor involved. It's just a.
And Your Honor, that may be your experience, okay? That may be your experience, but this court, you know, we all have contributed to this. This court, by allowing the public display that Mr. Brennan wanted to achieve in the initial application, brought the application to our attention, okay? And so that is what it is. Let's start with that. Number two, to your example, and using, Your Honor, I think you may be familiar with this, but what you talked about, you know, the typical process, and you made reference. Well, that's what the rules tell us. Okay, the rules. You start with the rules, but the Supreme Court of the United States has also told us something that might not be in that rule book, but we're all duty bound to abide by. And our Supreme Court in State versus Abadi told us something, which you might not find in that rule book, you sure will find it in its annotations, about the fairness of the role of the judiciary in the process. So that rule book has to be read in paramateria with the entirety of the jurisprudence that's applicable here. You can't say that 7:7-2, if I'm citing it correctly, that, you know, that's a be-all and end-all. It's not a be-all and end-all. You have to. That's right. That's right, and you have to read it in paramateria with the sections of the law that we cited under the Criminal Code 2C1-11A, and you have to read it in paramateria with 2C:1-3F, and you have to read it in the context of our jurisprudence and the cases that we've cited. But getting to your illustration, why is it that we are a jurisdiction that disfavors private prosecutions? Why is that? Well, one of the reasons is that whether it's Mr. Brennan or anybody else, we know prosecutors, and I believe Your Honor once was one. That's right. You know that you have a duty to disclose exculpatory information. You may have a duty in the process and even in the probable cause stage, determination stage.
We're not even there yet.
Well, yeah, but Your Honor, where we are is you have a checklist.
I have a checklist.
Right.
For my determination of probable cause.
Right, and I'm telling.
And it doesn't involve the state. And when the prosecutor say, I think at one point or another, Mr. Prosecutor, you got no place here. And even today, you know, Mr. Brennan we were off the record, I believe. Mr. Brennan, hey, Mr. Prosecutor, you know, stick around. No, he has no room here. That's his seat right over there next to you, Mr. Brennan. And I tell that prosecutor, if he was sitting over there today, I would say, Mr. Prosecutor, have a seat over there on the side or in the audience, because he has no room here, not for determination.
Your Honor, you're the one that makes the determination. So I'm adding to your checklist things that I believe you are duty-bound as a matter of law to consider, and I will check them off. The first is, I believe you are duty-bound as a matter of law per Coleman versus Alabama, to allow me to be here today to make those arguments as a matter of United States constitutional principle and my client's right to counsel.
In this case or all cases?
In this case,
In this case only, or in all cases?
I can only speak to this case.
I understand,
And
but-
respectfully, if you're asking me whether or not a probable cause determination hearing, it's not a hearing in a plenary sense, but we are in a room, there's a court reporter, you are hearing argument from counsel, as you said at the last proceeding we were here, inviting counsel to give our views on what that checklist
As a
should look
courtesy.
like. As a courtesy.
Only because there was some similar proceeding in some other jurisdiction, and in my understanding, you all know better than me, an assignment judge over there made a determination that counsel should have been present to, and I disagree with that. I disagree that counsel attaches when there's to be a determination of probable cause exists.
Well-
So that's where we start. So because the prosecutor doesn't, when I get a call at 3 in the morning from an officer saying, Judge, I have something in your queue, can you please go into the system, take a look at it, determine if there's probable cause, and so I say, okay, fine. And so what I do is, I do just that. Now, I make a phone call to any prosecutor to say, Mr. or Mrs. Prosecutor, can you please provide your perspective, your arguments, or what have you, and I certainly don't call any public defender or any defense attorney and say, hey, I just got something in the queue, can you provide your thoughts, and should I consider any case law or any statutes or anything like that. Generally, it's more fleshed out after a determination has been made against the individual. So I've determined probable cause exists. Now, all of a sudden, that triggers the system to come into play with all of the players, right?
Right.
Now the prosecutor has to be present. Prosecutor has to sit there now. Defense attorney, person has the right to counsel. Many times at this level, individuals choose to waive their right to counsel. But they have the right to counsel. And that's one thing that I inform every particular individual. Right before you, there's a big stack of papers, public defender applications. I inform individuals that application exists, how to get that filled out, what it says on the first page, what have you. Now, everyone has the right to counsel, and then all of these determinations, arguments tend to be made as information is received from both parties. If you were here after probable cause determination was had, and you said, Judge, look at this particular statute. It says clearly, this, as you mentioned, double jeopardy is applicable. I ask you to consider that. Now I take that stuff into consideration along with all of these other things that you've argued in your papers in here today, and on the last occasion as well. But those things are generally not handy by a deputy court administrator, or an officer, or even me when I'm on my tablet at 3 o'clock in the morning. So it's a probable cause is a very simple thing to determine. Should all the information be there, be present? So we start today with my position that certainly individuals have the right to counsel after that person is accused. And so right now, Mrs. Samson is only accused, if you will, in the mind of Mr. Brennan. I haven't determined anything more. Mr. Brennan is coming to the court to say, please, consider this document and all the documentation and whatever I have to say to find Mrs. Samson should go through the system.
So where I'm confused, Your Honor, is I haven't completed my argument, Your Honor.
Please.
He's repeating his argument over and
Mr.
over
Brennan,
and
Mr.
over.
Brennan.
Would you
Brennan,
admonish
Mr. Brennan.
Mr. Brennan to allow me to
Brennan,
complete
please.
my argument?
And Mr. Brennan's been paid. I'm going to give you the time, Mr. Brennan. And again, it's kind of courteous on both ends because Mr. Brennan, although you're a skilled advocate, you're a complaining witness. You're not here as an attorney or prosecutor at this particular time. And you make arguments, very, very solid arguments, and again, you're doing very well for yourself. But in this particular instance, all I would do with you, Mr. Brennan, if you came here and you had an ice cream cart right outside there, the federal building down the street, and someone snatched some money off of the counter there, all I would do, and I think I mentioned it last time we were together, I would just ask you a few questions. Ask you a few questions. Here I am giving you the opportunity to sit at a council table, make arguments, reach out to me on vacation, submit papers, and so I've done more than what I think I'm called to do, but I'm trying to do the best I can for both sides, for you, Mr. Brennan, and for Mr.
And that's highly respected, Your Honor, but to make my final point on our ability to be heard, and then if Your Honor will hear me on the textual arguments, unless I'm not entitled to be heard.
I'll give you the courtesy. Listen, right now we're still on courtesy. You too,
but
Mr.
the point, this is deeper than courtesy, Your Honor, with all due respect, because you invited by your determination, and I respect it, but we can't call this other than a hearing in the sense that the judicial processes have been invoked. And when they have been invoked, as the Supreme Court has told us, whether informally or formally, and to the extent you've characterized this as a courtesy, to me that is a synonym to informality, because it isn't formal, then we are here and we are where we are. And let's not forget what the accusation is. We're losing all of that.
No,
Your Honor,
we haven't lost that, because I just wanted to focus early on.
All right, fine, Your Honor, but the accusation is a serious accusation that if Your Honor signs this complaint that Mr. Brennan put in, those same 1,000 newspapers, the media that's in this room, they're going to say, complaint issued on probable cause basis against Dave Samson for official misconduct. That's what they're going to say. Let's not mince words. That's what's going to happen. And then Mr. Brennan will have a prop for his gubernatorial effort, just like he sought to have a prop against the incumbent governor, just like he's seeking to have a prop against the mayor of Parsippany. Okay? So it is not the ice cream case, Your Honor. Let's know what's happening here. That when you put pen to paper, if you choose to do that, that's the consequence. And that's the very consequence that our Supreme Court in Lloydman and our Supreme Court in Storm said, we don't want this process hijacked by people for those personal agendas. You have an opportunity, Your Honor, to abate that. Whether you want to hear from me or not, I'll sit down and shut up. But you have not only the opportunity, you have the inherent authority to kill it before it gets to that place. It isn't just this ministerial act that's happened this way all the time. I'll put my pen to paper. Now we'll move to the next stage. The damage is done when you do that. And you shouldn't do that here. You shouldn't do that here for all the reasons we've articulated. You shouldn't do it here because he doesn't have personal information with respect to the allegations. He's bootstrapping already on a complaint that already has been issued, prosecuted, conviction, sentence is being served. You can't do it because the statutes tell us it's duplicative, and you have the inherent authority, whether it's under federal law, whether it's under case law or the statute. So, Your Honor, I implore you to exercise your discretion and your inherent power to not render a probable cause determination simply because a complaining witness comes in, duplicates a bunch of papers in the federal. Imagine what that would do to our system in plea deals. Can you imagine what that would do? This is a result of a plea agreement. Do you think people will enter into pleas with other jurisdictions, whether it's the federal jurisdiction or not, if they could walk into this courtroom or any courtroom in New Jersey, grab the information, grab the indictment, said the prosecutor didn't bring it over there, I'm bringing it myself, put the badge on my label, I'm the prosecutor. There are policy considerations that you need to consider in this determination. We implore you to consider those. I appreciate and respect the attention that you've given to this.
Thank you. Way to come back from vacation, right?
All right, so Mr. Genova thinks that what I'm doing is somehow besmirching the fine reputation of his bribe-taking, extortionist client who intentionally used the power and authority that was vested in him and entrusted in him to get himself a special flight from here to Columbia, South Carolina. And somehow I'm the guy that's screwing up his client's reputation. And that's what's wrong with Jersey. His client is a goddamn criminal. His client, I don't care if you object.
I object to the use of
His client,
I object to the use of profanity in the court.
I said your client is a goddamn criminal. And that is an undisputed fact.
Mr. Brennan, I've been more than courteous with you. Respect.
And this-
Wait. Let me finish. I've respected you. I've commented positively on some of your arguments. Now, I think I just gave him a little bit of hell when I talked to him. Because my biggest concern is whether he should be here at all, right? Now, I used the term courtesy, he used the term informality. But if we use those terms, as one and the same, note that your place on this record is just that. Courteous, wait. But, I, and Mr. Genova, I didn't invite the media here. I didn't approve them to be here either. My superiors, I can't say, you could be here, you can't be here. My superiors, they approve those individuals from the media to be present today. And I have to accept that. Simply what you saw me do today and in the past while we were off the record and not being filmed was just to make sure that we're all on the same page. So there's been a couple of outlets here today that have been with us in the past, and we've come to some agreements. There's a new gentleman here today. Just want to make sure we're on the same page. I have to accept them being present, but it wasn't my call. Now, being that they are in fact here, I would be hopeful, Mr. Brennan, that your commentary just a moment ago wasn't for that purpose.
No.
Because I've treated you with dignity and respect.
Okay.
I understand. And I would want you to treat, the process in the court with the same dignity and respect. And so there's one reality that I'd like to point out now, and that's it. Everything is being recorded. And should there be a need to pull these things and have it transcribed, it's impossible for any person doing that when there's people arguing on top of one another. So that's a reality. So I tell everybody in my court when these type of things start to happen, that we have to speak once and only once. So that's why I gave him the opportunity. I gave him a full opportunity. I let him be heard. I asked him some questions, but I gave him the opportunity. I saw Mr. Brennan, you wanted to make comments. I said, you'll have your time. You have your time. And so now's your time.
Okay.
Right? Now's your time. But I don't like, and I would like to consider all of us here on the record at this time, gentlemen. We're gentlemen. And we should treat one another as such. And so Mr. Genova has pushed the line and said certain things about you on the last occasion and this occasion that I see as you're sitting there. It's offensive towards you. I understand that. And I thank you for being courteous with me on the last occasion and for the most part today. But please be mindful of your language. And I'm going to ask both of you if you have the opportunity to speak throughout this, this determination. I want to make sure we call it that you're respectful to one another. Okay? Now, I want to get us all out of here as quickly as I can. I mean,
I'll be brief. I promise I'll be brief.
I've been on the bench since this morning.
I'm just going to address some of the fallacies that have been put forth in this courtroom by Mr. Genova. And let's get back to something. This individual is trying to conflate my status as a citizen complainant with that of a private prosecutor. And he relies on Lloydman, and he relies on Dennis, and he relies on a series of cases that all deal with what happens after a probable cause determination is made. Right now, there is no state action. There is no prosecutor. There's merely a complaining witness and a neutral and detached magistrate determining whether or not probable cause exists and whether or not, if probable cause exists, the crime occurred within the statute of limitations. Comes right out of the rule. That's right on your checklist, that's what you do normally, that's what most determinations are based on. Statute of limitations, elements of the offense. Now, I stand by my assertion that this man's client's reputation has nothing to do with anything I did. He besmirched his own reputation by in extorting bribes, accepting bribes, and retaliating against United Airlines for refusing to acquiesce in his attempted extortion. So any publicity that comes as a result of this particular proceeding has nothing to do with me besmirching his reputation. The world has a right to know that he represents a criminal, a convicted criminal who did, in fact, in a petty and vindictive manner, pull from the agenda of a Port Authority board meeting the airplane hangar that he was using as leverage to extort that special flight. Now that happened. Nowhere in any of today's argument did Mr. Genova say, my client is innocent. His client is guilty. He can't do that. But the court doesn't say, well, we're not going to allow cameras because it might affect a particular defendant's reputation. They do it for family matters, no cameras, juveniles, no cameras, certain sensitive sexual assault cases, no cameras. This doesn't fit in any of that criteria. So he can moan and cry and whine about the cameras being here. But you know what? The light of day is a strong disinfectant for corruption, and that's what I'm doing here. And as far as my standing is concerned, I did this in 1997. I brought a criminal complaint against the mayor of Passaic, New Jersey. And Judge Wolf Semay of the Passaic Municipal Court refused to take my complaint, claiming I had standing. I brought that judge to the Advisory Committee on Judicial Conduct, and they drafted a presentment against him, and they removed him from the bench, in part because of the complaint that I made against Judge Semay. So the idea that I don't have standing got Wolf Semay in trouble when he said I had no standing. Now, I provided you with the transcripts, 3 separate hearings, full-blown hearings, not just determinations, in Judge McGeedy's courtroom. They invoked State versus Christie repeatedly in their paperwork, and they only told you what they wanted you to hear. But if you read the transcript and you read the excerpt, Judge McGeedy was upheld in every manner on my standing to bring the complaint. Judge McGeedy was upheld in every manner in his determination that the gravity of the offense is not a limitation on a citizen's complaint. But if you read their papers, you'd think Judge McGeedy was overturned. Judge McGeedy was never overturned. The case was remanded back to him for further proceedings. He did the same exact thing. He rejected each and every one of these arguments regarding standing and the gravity of the offense, and the assignment judge upheld him every way. The case was not dismissed by a judicial officer. They're trying to tell you that because a prosecutor in State v. Christie dismissed a complaint, that you're somehow bound to do the same thing. In State v. Christie, the prosecutor that dismissed the complaint alleged that he could not get a conviction beyond a reasonable doubt, despite the fact that probable cause had been found. But the probable cause determination was upheld in every way, for every reason, by Judge Misdahl when it was brought up on appeal. So, with respect to critical stages of the proceeding where the right to counsel attaches, you pointed out something fundamental to this argument. We are not at a hearing. This is simply a determination. It is like the difference between a lineup and a photo array. At a lineup, the defendant has the right to counsel present for the lineup to make sure that you don't have 5 people wearing suits and ties and 1 wearing ripped jeans, etc. But when you do a photo array, the right to counsel doesn't attach. And I would posit that a probable cause determination is akin to a photo array. And if you want to have a hearing, that would be akin to a lineup, where the Supreme Court has said you don't have a right to counsel at a photo array, but you do have a right to counsel at a lineup. And it's the same thing. You're identifying the assailant or the perpetrator for the purposes of bringing a charge. So if I were in the Newark Municipal Court and they put a lineup together with David Samson and a bunch of other rich, wealthy former attorneys general, and I said, that's him, and Mr. Genova couldn't be there to say, hey, you know, all the clients didn't look as rich as mine, so mine was singled out, well, then that lineup would be thrown out. But if they showed me 6 pictures and I picked the picture of David Samson out of the 6 pictures and said, that's the perpetrator, Mr. Genova would have had no right to be there. But Mr. Genova slipped up in his argument. He mentioned, I think it was Abate, he said that when the state government, when state action is involved, you have the right to counsel. I don't see the state. It's me. The state got up and left There is no state action here. And that's the critical difference between what he's trying to conflate, which is a private prosecution after probable cause is found. In my papers, I begged Your Honor not to put me in a position where I had to act as a private prosecutor. I begged Your Honor to stop hearing legal argument because I'm not equipped and don't have the resources to respond to Genova Burns and all the money behind.
I told you before, too, you're doing very well.
Well, thank you very much. But again, I'm not a typical litigant, and what we have to be mindful of is what the process is going to be for everybody who comes before Your Honor. And the people who come before Your Honor would never be equipped to deal with this sort of argument. The idea that we're going to have a full-blown trial as to whether or not you'll even make a determination. You don't have the resources to do that. This has taken up 4 appearances over 3 weeks and 7 hours of municipal court time on something that generally takes 5 minutes. And that should tell you something. 5 minutes for every other defendant. But the guy who used to be the Attorney General, who got nominated to his position by Chris Christie and confirmed by the Senate, is tying up your courtroom on a different process because he's got money. And that's not justice. And that's not the United States of America.
Well, I would say because he has money, I would simply say, listen, all I want to do is what's fair, what's right, and what's just. And sometimes it's unfortunate, that parties in an adversarial proceeding don't see a win-win. It's unfortunate. It's unfortunate. There's wins and losses in an adversarial system like this one, in a criminal justice matter, or system, I should say. So I have some questions for you too.
One more issue.
Go ahead.
He keeps talking about piggybacking and bootstrapping. But these are his terms. You know something? If the U.S. attorney for the District of New Jersey chose to grant immunity over state law crimes in exchange for that plea deal, he could have done so. That agreement would have been here. He could have invoked his authority as the U.S. attorney to say, in exchange for accepting this guilty plea here, we will grant you immunity from all charges related to this event. He didn't do that. He only granted him a plea deal for the federal charge that he was charged with. I specifically asked the U.S. Attorney Lee Cortez, who prosecuted that case, who was involved in the prosecution of Samson, whether or not this precludes a state law prosecution. And his answer was, that's a question for a state law prosecutor. Mr. Genova doesn't want the prosecutor involved. Why is that? Because the prosecutor has the resources to argue all these things. Now, with respect to double jeopardy, I don't know if we should even get there, but because he argued it ad nauseum and he cited 2C 111A, he stops at unless. He loves that statute until the part with unless. And then unless 1 and 2, throw him right out. Unless 1, the elements are different. Well, one element of official misconduct requires that you be a public official. Jamie Foxx, who recently died with a charge of bribery and extortion hanging over his head, was not a public official when he was working for United Airlines. He was charged under the same statute. So there's a different element. Another element of official misconduct is that you take an act knowing it's an unauthorized exercise of your official function. It could be as simple as removing an item from the agenda. That's an act. It is neither bribery, it is neither extortion. It is merely retaliation for resisting extortion, which is separate and distinct from the bribery statute, which he confessed to. However, once he confessed to the bribery statute, and he confessed that one of the things he did in furtherance of his conspiracy to engage in bribery and extortion was to remove that from the agenda, it's a separate element. And the pernicious harm involved in official misconduct is so much more substantial to the public. If I run a garbage route in Newark, New Jersey, and I've got the South Ward or whatever, the 3rd precinct, and that's all my garbage, and the guy from the neighboring community starts taking my streets. So the wise guy comes to me and says, you got to pay me a bribe if you want to get your stuff back. And I pay him. That's bribery. It's extortion. Neither one of us are public officials. Neither one of us are subject to a 5-year mandatory minimum term of imprisonment. Mandatory minimums are set for particularly pernicious evils. And in this case, the pernicious evil of official misconduct is consuming the state of New Jersey at a rapid pace. Now, this man wants to focus on the last 2 charges I brought, but he knows full well that I've brought criminal complaints as a citizen over the past 3 decades. In the 90s, I've done it. In the 2000s, I've done it. In the 2016s, I've done it. So the idea that suddenly, because I'm running for governor, his client can attack my motive in being a citizen and performing my civic duty is absurd, especially when he went before Judge McGeady with a backdated piece of
Objection,
evidence.
objection, Your Honor.
You can
I
back
object,
the
Your Honor,
objection.
object, Your Honor. This is no
There's nothing
bearing
from
on
the
this
objection.
matter.
You
I'm
made me
objecting,
sit
Your Honor.
down. I
He's
haven't
making
said
those
anything
statements.
wrong.
There's no basis for those statements, and I object to them, Your Honor.
Why don't you sue me?
Whoa, 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 stop, stop. I revert back to a statement I made earlier. Let's all act as gentlemen.
I'm being a gentleman.
So, Mr. Genova.
Tell me the truth.
Wait, Mr. Genova, you said certain things about him that I would have considered offensive if they were said to me. And Mr. Brennan, you're saying things, you know, that to him, that if I were him, I would feel the same, right? You're both jabbing at one another. And I'm allowing it to happen because you haven't reached that point. You did a moment ago.
Well, he cast aspersions about my motive, and I'm stating as a matter of fact and law. I have a copy of his deposition
Your Honor,
transcript.
Your Honor,
I have a
Your Honor,
deposition
Your Honor,
transcript.
this is beyond the pale.
You know what?
Your Honor, this is beyond the pale. He's
Mr.
making
Brennan,
personal
Mr.
attacks.
Brennan.
I'm here to
He's
argue a
interrupting me.
case,
I
Your
sat
Honor.
down.
I'm here to argue a case. I'm not here.
Okay, is that, we good? So, Mr. Genova, give the gentleman an opportunity to be heard. And Mr. Brennan, your courtesy is going to be pulled. I have a question for you. I have a few questions for you. I have a few questions for you as well.
Well,
But
I just want to put on the record.
Listen. Just like I did with him. I'm listening, all right?
He cast aspersions upon my motives for coming to court and signing a citizen complaint. And he represented a defendant in a case where I signed a citizen's complaint. And it was in 2003. And I was not a candidate for public office in 2003 when I did that. And as part of, prior to that case going on the record before Judge Roy McGeady in the Bergen County Vicinage Court at the time, before it was the Municipal Court of Bergen County, he had an ex parte communication with Judge McGeady, and during that ex parte communication, he presented a document that was dated August 18th, and that document had not been created until September 9th. It bore his signature. Now he's claiming he didn't put his signature there, that an attorney at his firm by the name of Laura Corvo used his signature stamp.
Listen, that's not here.
Your Honor, Your Honor, I'm going to strike it for the record. Your Honor, that has no place in this matter.
Listen, that's neither here nor there. Really,
So
let me, whoa, stop it. The reality is this. Here we are at a determination, right? I would have been done already. I would have had my lunch already, right? I mean, I thought I would have been done. I thought I was going to have my lunch. I thought I would come here feeling refreshed. You know, I come back today, the stack of mail is like this, the phone messages are like that. You know, the court was ridiculously populated. I was supposed to take another court's matters as well. I got hammered, okay? First day back. And then you submit some things to me, Mr. Brennan. You submit some things to me, Mr. Genova, in a short period of time. I thank you for not, you know, Monday, Tuesday, Wednesday, Thursday. I'm at the beach. I'm with the family. I was enjoying my boys. But then at the tail end of the week, now I'm reading all this material. So I would have been done with this hearing, or I should say, determination.
And that's the critical difference. Determination,
it's a
not here.
determination. It's a determination. Because I've given you both opportunities to be heard, we've expanded the time. But if you continue to make these arguments
I'll
against
take
one
your question and drop my point.
you make these arguments against one another, you jab and punch and kick at one another, it's not getting us anywhere quick. And so I simply want to say these things to you and then ask a question. And I'll give the attorney an opportunity to also weigh in if he wishes to weigh in and make some other statements. And I'll give you a chance to. And now I'm going to make my determination. Well, I'm going to be done. I'm going to go out to lunch, all right? So, and I have another training. It's gone. They're, you know, I had a training one time before, and the same thing. They sat in a room for a few minutes. I'm not there. They leave. You know, I've been getting text messages, and you know, so the training is done. Okay, but when I look over a complaint for determination, probable cause determination, right? I told you about this checklist. It doesn't exist. I've never seen a checklist that existed that's, you know, I don't know if they have a checklist or not, you know, the court administrators, deputy court administrators. You know, I don't know if an officer has a checklist. I've never been given a checklist to say, make sure that these things are present on the face of the complaint, and you've considered these other things and looked at the statute, and, you know, it happens. I've been doing this 20 years. I've been on the bench 5 years. You know, I just do this, right? I've been, as you mentioned, prosecutor a long time. County prosecutor here, chief prosecutor here in the city of Newark. This is what I've lived with all my career, these type of complaints. So I know them well. So I look at it just to make sure everything is where it's supposed to be, and make sure the content is there as well. And so, for the most part, Mr. Brennan, everything is there. I've looked at the statute. I mentioned to you the first time I think we were together that generally these things have a 5-year limitation. And, you know, I know, you know, homicides, littles, have, you know, limitations that just go on. But disorderly persons offenses, 1 year, you know. So we talked about that. You said, the judge, you know, the statute of limitation hasn't run, because I looked at the date, you know, I checked the book. 5, 6, 7 statutes get 7 years. So I think that's what I found when we looked at it before. So you were right. So the statute of limitations is right there. You know, you got the name. You told me the judge, he receives his mail at this particular address, you know, and what have you. So I'm looking through it all. Now, the one thing that, I looked at the statute, I looked at the elements, you know, you provided me with the information on the last occasion, which I have here in the file. I read through that stuff. They're asking me to consider some other things on the checklist, you know, this one particular statute, 2C1-11, if that's what it is, and some other things as part of my checklist. Now, I generally wouldn't have certain things on my checklist at the determination point, right? I don't know about those things. Those things will have to be, if I determine probable cause, they would have to be dealt with after the fact, right? You know, so we understand. My question and my concern, just like I had a question and concern for him, Mr. Genova and his staff member here, his attorney, whether they should even be placed here today, making these arguments. The right to counsel attached. And so my biggest question for you is in fact standing. Now, if we used 2 different examples, back to my examples, we have the ice cream vendor. Certainly, if she came into the court, it happened to her. She can, you know, if she knew the individual, she can provide all the information. So it just happened yesterday. I know the person, he's a customer of mine, he comes in, you know, every day for ice cream, whatever the case is, she provides that information. Probably cause a termination sign. Now, let's say, for instance, that person is you know, in that position, but challenged in some fashion, and has is in the care of someone else who has a power of attorney. Now, maybe that power of attorney would then come to court with the individual and say, Judge, you know, here's my documentation, you know, I have power of attorney, I want to, you know, relate what happened to her and give me some information. I would very likely listen and, you know, and give that person that opportunity to be heard. Now, this happened down the street by the federal building, and somebody's on the 9th floor drinking coffee, happened to look out the window and sees this happen, and then comes to the court and says, look, that person's the kindest person on the planet. I can't believe this injustice took place. I want to file a complaint against this person. The person's supposed to be the So, you here for the training? That's me. You good?
Can I approach this?
Okay, you need to approach me on the training or this?
On the training.
Okay, all right. We should be done in a few minutes. I'll give you a call. We'll skip the training for the day.
Okay.
Okay.
That's what I want to find. I'm leaving.
Okay.
Yeah.
Okay. So, now, let's say, for instance, the same person is drinking coffee at his desk, and someone who's at the window, hey, look what just happened to to the ice cream vendor. Person at the desk, drinking coffee, that person's a kind person. Why should that happen to that vendor? I'm going to go over to room 207 and file a complaint against the person. Let's say a couple weeks later, the same person drinking coffee now, comes into the office and learns from the office mates there at the cooler that something happened to the ice cream vendor. And so at what point, it's like, it reminds me of like proximate cause, we've all gone to law school. So it's like, at what point does it get so far away, right? I'm going to give you an opportunity. Because, and then my next example would be, and this is what comes to mind, right? This is what starts to come to mind as you make these arguments from the very beginning. And I asked you some questions, and you said the very first time, you said, Judge, I have the right to, bring a complaint, have you said something to that effect. And certainly do, just like I mentioned today. Everyone has the right to come and bring forth a complaint. You don't have the right for one of the persons that has the authority to make a decision to then check probable cause. You don't have that right, but you do have the right to come and make a complaint, right? So United, the CEO, that person came in and said, Judge, this is what happened. And that person was like, in this discussion, immediate, discussion and this unfortunate agreement for them all. That person, I would, okay, I'm listening, and maybe somebody else who was affected from United in some capacity. I would listen to them. But I have concern that you're so far away from the actions and activities to consider, that you in fact have standing. So I want you to go ahead and tell me. That's holding me up.
Well, in the first case, we're not nearly as attenuated as the guy on the 9th floor drinking coffee, hearing from somebody who witnessed it through the window nine stories down. More akin if I was standing online for ice cream and the person in front of me, while I'm there with my young son, commits an armed robbery in front of me, and the victim of the armed robbery is afraid to go to the police, but my son is in tears and crying, and I don't want to live in a society where armed robbers are robbing ice cream people. I have every right, because you got to look at the plain language of Rule 7:2-2. It says any complaint. And then you got to look at the rules of evidence that say hearsay is admissible in one of these proceedings. And I don't have hearsay. I have a record of conviction, which is not hearsay. It's not even an exception to the hearsay rule. It is a public record. And that public record establishes every element of the crime. And as a citizen of New Jersey, any act of official misconduct touches upon me as a resident and a citizen and a taxpayer and a human being. Because again, the pernicious evil involved in selling your office out. The Port Authority was used as a personal piggy bank, as a weapon against people, as a carrot for people. All of that went on in the absence of any integrity from prosecutors. They may very well take this case and discard it. But the process thus far, what's been written in the rules of court, allow me to do this. What was upheld by the assignment judge in Bergen County. I wasn't present when David Wildstein told Chris Christie, we close those lanes and Sokolich is angry. I wasn't present for that, but I heard the sworn testimony. I had enough information to believe that probable cause existed and bring this to a prosecutor. That's the point of this process. Now, the Port Authority, I am a customer of the Port Authority because I use the bridges and tunnels there. I am a customer of United Airlines because I fly that airline. I live in New Jersey, and they're the dominant airline out of Newark, New Jersey. I have been affected. United Airlines had to pay millions in fines for their part. So saying, well, Munoz or whoever, Bethune, or whoever was in charge, the CEO of United, should have come in and confessed that he was engaged in a conspiracy with Jamie Foxx and David Samson to pay bribery in exchange for this extortion threat, to expect those the participants in the conspiracy to self-report is an undue burden on the system, because conspirators don't confess unless they're caught, and in this case they were caught. United paid. Jamie Foxx died awaiting trial, and David Sampson's going on vacation for a year to the very place that he was extorting United Airlines to take him to. So the role is not that attenuated because the court was open to the public. They were public proceedings. It was open and notorious. When that individual killed somebody on Facebook, If that had happened in New Jersey, and for whatever reason, if it happened in Newark, and the Newark police decided not to prosecute that person, I would have had every right to bring the Facebook Live videotape of a murder, a random and horrific murder. I could have brought that into room 207 and said, I watched a murder on Facebook, and here's the video, and signed a complaint. And nobody would question my standing.
No. Let me say this. You could have done it. You could have done it.
Fortunate.
And wait. You could have done it. Again, I stress that the book says, the court rule, you have the right. You can. Every complaint must be taken. So I said, person can't see an individual come into the window. I'm just exhausted today. I'm not taking your complaint. Come back tomorrow. Can't be done. If those windows are open from 8:30 to 3:30, those complaints must be taken throughout that time. There must be somebody at that window, whether it's 1, 2, 3 people at the window downstairs. It must be taken. But probable cause doesn't necessarily attach. There's a determination. And so I ask you, because you can go downstairs every single day and file a complaint against somebody new, anybody you wish to file a complaint against. You can do that every day. You can file a complaint against every individual that's in this room or outside of this room.
Provided I have evidence. I can't just come in and sign a complaint. I have to.
Wait a minute. Some people do come in. My witness, she does this every day, but she's not here. People go downstairs, file complaints. I had a person who said that Peter Harvey, this is I was a prosecutor here, that Peter Harvey, former AG here in the state of New Jersey, was stalking her, that he was looking through the bathroom window and her bedroom window at nighttime. Now, she didn't have any evidence outside of her testimony. Now, certainly, there were a number of questions asked of her, and probable cause was not determined. Now, I've had individuals come before me and against the President of the United States and all these other individuals and say some of the strangest things with no evidence. They still have the right to come before the court and file the complaint. The complaint does not have to be then fulfilled.
But Your Honor, you had to weigh the evidence, and that's all I'm asking you to do. And the weight of this evidence is so heavy that it is sufficient to get, when you have enough evidence.
But it's not about evidence at this moment, because the question that I had for you was simply this, was your standing. So you're standing right now.
I'm standing.
But what is your standing in this case? Because yes, I told you from the outset that you've provided me with all of the information that I would generally need on my checklist, right? But the one concern that I have, just like the biggest concern I have for him, is whether he should even be sitting here making these arguments, because I don't believe that the right to counsel attaches this early on. And so there's standing. And I try to provide you with various scenarios that the closer an individual is to the actual offense gives some comfort, if you will, for me to then make a determination that.
But you're turning the rule on its head.
No,
the rule is set forth for circumstances where the police or the prosecutor will not act. And
wait, where does it say that?
It says a citizen can bring any complaint for a probable cause determination. It doesn't require personal knowledge. That's been dealt with. 722A.
And Mr. Genova, I'll give you an opportunity to be heard as well.
And by the way, the assignment.
Go ahead.
I don't have.
Look.
I don't have.
Not by the way, if you're going to make such a strong argument.
Well, the warrant says any violation, any. 72. Look, you got the book in front of you.
Listen, let me say this to you. You've been pretty good with that cell phone. You haven't, this is your third time around. You haven't bought a tablet or a laptop, but you've been more than excellent with that cell phone. So if we're at the point where you're going to persuade me or not, I want you to go ahead and point to the language in a way that's accurate.
Okay. process.
Just take a read of it, okay? And Counsel, you all have it as well? I mean, I have the book right here. It's very simple for me to make a copy over here. The copy is just to the side for both of you, or all three of you. My office is ready to make a copy. You need a copy, Counsel?
We're okay.
You okay? Mr. Brennan, you need a copy? It takes a minute.
Should be easier than this.
Okay, let's do that. So what I need, officer, is it, and it's good to stretch my legs for a moment. This page right here. This page in the second page.
Independent media.
Yeah, front and back of this page right here. And if you make 3 copies, we'll give them all 3 copies. So we're all on the same source, okay?
Citizen complaint.
Whoa. I've taken the opportunity to stretch my legs and stand up. This officer right here is going to do a courteous thing, make each one of us a copy of the same thing. So we're all looking at the same document. There's no misspellings, a dated, a source. It's all coming from the same book. All right? So you take the opportunity, Mr. Brennan, to read that over. Okay. Go ahead.
May I take a moment while you're doing that?
Please. You need to use the restroom?
Yes.
Okay. Let's go off the record. Let's go off the record. Let's go off the record. Do this. Slipping down. Just call my wife. Okay, so...
So your question about standing, I think what instructive is the rule on issuance of a complaint, warrant, or summons, A, 72:2-2, subsection A1, citizen complaint. And it says, a complaint, warrant, or a summons charging any offense made by a private citizen may be issued only by a judge, or if authorized by a judge, deputy court administrator, of a court with jurisdiction in the municipality. These are the limitations. A court with jurisdiction in the municipality where the offense is alleged to have been committed within the statutory time limitation. Well, Newark Airport and that particular terminal.
we're beyond all of that.
Okay.
We're beyond all that.
So
All I want to do is, I want to...
The only limitation so far in this rule about a private citizen deals with jurisdiction of the court territorially and statute of limitation jurisdiction. There's no limit on standing. And remember, 20 years ago, this rule was the same. 20 years ago, I was denied the right to sign a complaint based on standing, and that judge faced discipline. So nothing has changed. Last year, I did the same thing. I brought a complaint against Governor Christie, and that judge found that standing is not an element. The issue is whether the evidence is sufficient to rise to the level. He did the same checklist you did. Is it in the statute?
Well, I don't know if he did that. I mean...
I gave you the transcript.
Yeah.
I gave you the transcript, and he ran through pretty much verbatim the things that you talked about. Is it within the jurisdiction? He said it could have been in Trenton or it could have been here. It's both. I'm assuming that it happened in Fort Lee. I have jurisdiction as a Bergen County court. Next, he said, is the statute of limitations? It's 7 years. The event occurred on 2013. That would run until 2020. Then he rejected the argument on standing. He said any complaint brought by a citizen, and I don't read that to be a term of limitation. And that was in his decision that was upheld in its entirety by the assignment judge. But here, it says, the complaint, warrant, or summons may be issued only if it appears to the judicial officer from the complaint.
Say that again. Where did you start?
I'm in the middle of subsection A1. The complaint warrant, parentheses, CDR-2, or summons may be issued only if it appears to the judicial officer from the complaint, affidavit, certification, or testimony that there is probable cause to believe that an offense was committed, that the defendant committed it, and a complaint, warrant, or summons can be issued. The judicial officer's finding of probable cause shall be noted on the face of the summons or warrant, and these are all shalls, and shall be confirmed by the judicial officer's signature issuing the complaint, warrant, or summons. Now, it doesn't say anything in that court rule about my standing. I am not an interloper. It is called a private citizen's complaint, and I'm bringing a private citizen's complaint because a violation of law occurred. I've told you I've been affected by it, but the rulings that, again, in the Passaic case, it was a Democratic mayor who had violated the rights of a Republican municipal employee. I didn't know any of the parties. I went in there because, in my view, when you don't have the law being applied equally. When some people are above the law, we live in a dangerous place. And it is my duty as a citizen to ensure that the law is enforced fairly and impartially. And we all have that duty as citizens of this great nation. Very few duties we have. Jury duty, register for selective service, and make sure that the administration of justice is fundamentally fair. And I am doing that. And I'm being castigated for it by the people who broke the law. And that's not appropriate. To cast aspersions about my motives as a citizen in trying to make justice work for everybody is un-American. And that's where we are now. Somehow, a simple determination, is there enough evidence, did it happen in the territory, and did it happen within the statutory time limits, has now devolved into, am I sufficiently affected by it to have a stake in the matter? We all have a stake in the administration of justice. We all have a duty to make sure that crimes aren't committed by public officials. I am upholding my end of my duty and my bargain with the United States of America as a citizen, and that's all I need to do. This would be the first time in the history of the state of New Jersey that standing was used to preclude a valid complaint. Again, 3 things before Your Honor that you had in your mental checklist, that Judge McGeady had on his checklist on the record, and none of them involved how was I personally affected by it. Under your example, if the ice cream stand is on my street and I don't want a thief hanging around my neighborhood, and the ice cream vendor is okay with getting robbed, I have a right to say, you know what? I witnessed an armed robbery today, and I want that man arrested. No court is going to tell me, well, who are you? He didn't rob you. That would be like I walked by and I saw a rape going on, and I chose to do nothing because I had no standing to help the rape victim. Guess what? I stand up. Some people in this world are not stand-up guys. Some people in this world don't get involved. I choose to get involved, and that used to be an admirable quality in America. Something's going wrong where suddenly the guy who stops the rape, the guy who stops the armed robbery, the ice cream guy, the guy who wants to hold the corrupt public official accountable is now suddenly the bad guy.
Well, let me say this to you. I'll give you the opportunity to hear too, President. In many of those instances that you cite, and, use examples, and that's good because we could kind of stretch them a little bit. Oftentimes, the police are involved. Some let's call it law enforcement, right? Whether you go to the prosecutor's office here in New Jersey, at one of the counties, or you go to the one of the local precincts, or what have you, they do an investigation based on the information that you provide, and they make a determination that if probable cause exists based on their review, their findings, their study, if you want to call it that. And so they are, the prosecutor's office in particular, are under an obligation to make certain that they're not prosecuting people just to do so. I mean, when I was the chief prosecutor here at the city of Newark, I read very closely this statute that says, I have a duty to defendants as well as, to the witnesses, to the victims, I should say, right? So I took that with great weight. I didn't want to go ahead and perform anything that was not just against a particular person. It was a duty. It was a duty that was written, black and white, clear as day. So, there's one thing for a private citizen to come into the building and make a complaint. Determination, probable cause. Determination, no probable cause. That's not your choice. That's our choice in the courts or the police officer's choice. Now, if in fact probable cause is found, now the prosecutors have to make a determination if you cited to it before, in part, whether they could prove a matter beyond a reasonable doubt, whether they are fulfilling their duty to defendants as well by moving forward. I mean, you have to look at everything. So you may want certain outcomes, but the reality is certain outcomes may not exist because you're not the individual that you could come in very easily and make the complaint, but you're not the one on the other end that has to go ahead and prove it and to do so before a jury oftentimes. And so wait a minute, it's them up there that have to make those determinations, and they have certain duties that you don't have. So I'll listen to what you have to say, and then I know Mr. Genova was.
Well, I mean, except that you're now going beyond what's before us. Your function here is to determine whether or not probable cause exists. And
It is.
And all of those other ancillary issues about whether the prosecutor can get a conviction beyond a reasonable doubt, whether he thinks it's in the interest of justice to continue this, whether the prosecutor wants to exercise his discretion to administratively dismiss the complaint, they don't come into play until the discrete functions of this determination are upheld. Is it within the statute of limitations? Is there sufficient evidence to believe a crime occurred, and did it occur within the territorial the territorial jurisdiction of this court? Those are the three things that are spelled out in this particular statute. Going beyond that now is premature. And I believe, by the way, I have told you that I am personally aggrieved by what Mr. Samson did. I am personally offended by it. I have a deep and abiding belief in the rule of law. I have a deep and abiding belief that public officials must not engage in official misconduct. I find it an affront to any notion of fair and impartial administrative justice that this man is going to go on vacation after extorting millions of dollars, after causing millions in fines, after letting another man who he extorted die under the specter of criminal charges. I am personally offended by that.
So let me ask this, because there's a lot of room for you to go ahead and take action against an individual like that. So what he did was an injustice. What he did was, let me tell you, so he, from what I recall while I was in law school and thereafter, he belonged to a very reputable firm. A firm that I would think was one of the largest firms in the state and probably was, you know, well into the millions of dollars in profit yearly. You know, he was a major partner. I would have to believe, you know, you cited that, you know, he's wealthy in many different ways. You said that. I would have to believe that he was in fact wealthy. He was well connected. In fact, he became, you know, he had the title of a, you know, great substance. He was given that opportunity. He was a chairman, you know. I mean, Port Authority is huge, right? I mean, I have people that I know that just die, you know, if they could just become a Port Authority police officer. Forget about the chairperson, right? Wow, you know, it's huge. He said yes. You know, we travel along their highways, their bridges, whatever the case may be. There's a lot of influence there. He was a man of great repute and status, and I'm sure he could have done so much with his career. And so at the conclusion, I don't know how old he is. I told you, so I play with my kids. I don't play with the, you know, looking up details. I don't care about that. I do what I'm supposed to do for my job. I'm not trying to research everything about the world. You know, if it relates to my boys, I do it right. I'm not trying. I don't know his age, right? And so I've never met him. You know, I don't. If he was right in here, I wouldn't even. I would think it's him because I saw pictures of. I don't know. You know, they talk about you. I don't know about you. You know, except what I've heard here. I didn't research you. I don't. You know, I research for my boys. You know, what size baseball glove does he need? You know, what size bat should I buy? You know, what weight would I? That's what I'm doing. So. This individual, he could have left this planet with the most solid of reputations and probably would have gotten other opportunities to serve this state, this country, his fellow men. And you know what? He is a disgrace at this time. It's unfortunate for a man who has plotted so well over the course of his time, his career, and has done so well. He is almost with a plague. He had to leave it's South Carolina. You know, he can't walk. I mean, the firm has changed its name to something or another. He probably can't go in there comfortably and sit where he used to sit, and he certainly can't attend. I'm going to a function in a couple of weeks at the Essex County Bar, and I'm sure he can't just come in there and feel comfortable. People don't want to sit around the guy. His family, they may still have the proceeds that he's, you know, brought about over the course of his years, but, you know, his reputation is not good. When his children and grandchildren and great-grandchildren read about him, I don't want that to happen, you know, most of us who have children, we want the kids to look up to us, think that, hey, we did our part, Not for him, not for him. So he has to, perhaps the worst jail that he has is his old self.
Well,
Listen. He has to look in the mirror every day. See, you, just like me, you move on with your day. You may say that you're offended and you were affected, but at the end of the day, you move on with your life. If you have family too, we've never discussed it, but if you have a family too, that's your priority, really, or should be, in many people's perspective and view. So that person has to live with it. He has to look in the mirror and say, you screwed up, maybe in harsher terms.
in the immortal words of Detective Tony Beretta,
Okay.
don't do the crime if you can't do the time.
So-
And he did the crime, and I didn't see him standing in any county facility before.
You didn't see that, like what we saw in the booth there. People were.
I didn't see him spending time in jail. I didn't see him getting processed like a regular citizen. I saw him, he wasn't even indicted. He got a deal before the information was even issued.
So look-
And the system is
Can he
being
I don't even know, can he practice law
It's
anymore?
been suspended.
He's suspended, right?
suspended.
So he's not,
But-
so he's, listen, so he's not practicing law, he's on a probationary period, he's had to pay a substantial amount of fine, maybe not, for his monies, maybe not a whole lot, but for me, that would put me in a hole, right? You as, other people too. So, his reputation is completely damaged, So, you, on one hand, let's say for instance, let's say he got 6 months jail. That may not be satisfactory to you, maybe to another person. This stuff is very subjective in what we deal with, right?
No, unofficial misconduct.
Listen to me.
Pretty cut and dry.
Listen to me. Forget about, I'm talking about what he's doing right now. Because he has pled guilty. He was in fact sentenced. And he's doing his time in one way or another. It's not a jail term, it's not a prison term. But if he had served some jail or some prison, would you be satisfied?
Yeah.
Well, you would be satisfied.
If he spent time in jail, I would feel that justice was served.
Okay.
You know what? There are people in jail right now for far less. And the difference is they're either people of color or they're people without means, and they're doing time. And you know what? You talk about my family and my kids. I want my kids to grow up in a country where the fact that their dad's not rich doesn't put them behind the 8 ball, behind Samson's kids and grandchildren who can do whatever they want and never see a day in jail. You know something? It's equal justice under the law, equal protection for all. And this isn't equal. Bridget Kelly's going to do time. Bill Baroni's going to do time. The corner boys as opposed to the kingpin. So this is in my view, you talk about me caring about my kids, we are losing our freedoms in this country. And this is near and dear to me. We are losing faith in the fair and impartial administration of justice. People, I don't know what circle you're traveling in, but the circle I'm traveling in, people are fed up and disgusted, and they have no faith in the justice system anymore. They have no faith in the county prosecutors. They have no faith in the attorney general. They have no faith in the United States attorney to see that justice is done. They see people getting away with crimes because of who they are, because of how rich they are, because of what connections they have, and they see other people on screens here doing time because even though you have bail reform, they're sitting in jail because they can't afford the Genovas of the world.
Okay, let me ask something of you. I'm going to ask something of you, and then I'll give you an opportunity to hear in a moment. I don't believe, did you represent Mr. Sampson in this matter in the federal courts?
I was not his criminal defense.
Okay.
I was part of his team, but I was
Was that done right here? Right here? Is that right?
right down the street.
So
Before the chief judge, the sentencing judge was the chief judge of the United
Judge
States
Linares?
District, Judge Jose
okay,
Linares.
so what, and I'm here in this room that's, I don't know, 2 blocks away. You got Franklin Street, and then you have the next street over there that's blocked off, and then there's the federal building. So I don't know which courthouse it was held in, but there's a couple, there's one across the street where
The new one.
the new one with the statue in front, right? 2 blocks away. 2 blocks away.
The erring human heart in turn must do its public part and learn.
So, situation is this. Now, from what I understand, or I'm here every day, I didn't see any parade of individuals in this area here, around the building, protesting and arguing, or I don't know if the U.S. attorney has received, numerous letters. You have never mentioned either whether you sent letters, if you appeared for all of the proceedings. There's opportunities for people to be heard regarding matters, right? And so, one thing that, you say that there was an injustice had, but there's an opportunity to make sure that justice is done, not after the fact, but while that matter is going forward. Because let's say, for instance, the statute didn't exist, the one that we're discussing today in this particular determination. What do you do then? If you're so disgusted with the system, there's ways and means to go ahead and protest and argue against all those individuals that are part of the system that's not working. Now, I try my best. I try my best to do. I'm taking the time that I believe the matter needs and deserves. I've taken the opportunity to hear from either side. I've taken the opportunity to read what you submitted and read other things as well, and to contemplate, these things. So I'm trying my best to come to a resolution that I believe is right, that is just and that's fair, and I've questioned both sides. And so, again, this is extraordinary, completely unusual, but I think it deserves it, right? I think it deserves it nonetheless. But just to make statement towards your statements, you could have been right there. You could have been fighting the fight for all of the people in this, including myself. Because me too, I get on those airplanes, and I take those, I got my easy pass. I pay all that money. I think it's ridiculous, but I pay all of that money to travel all around these highways and byways and bridges and what have you, and Port Authority is, taking my money every single day, and there's injustices and things may fluctuate because of things that have happened in terms of the number of dollars I have to pay now because they need to go ahead and compensate for their losses. So I understand that. And of course there's injustices that we need to, as Americans, continue to stay the course and fight, so that all those things that were meant for this country remain and do in fact exist. We have to do those things, right? But it's unfortunate that every single day there's injustices and inequality and what have you related to race and gender and all other kind of things like that. Every single day we have to fight the fight. And so certainly individuals like yourself and institutions and profits and just the common day person fights the fight. That's what we need. ACLU and all those other groups. We need all of those groups, the watchdogs, if you will, to make sure that everybody else stays right. So go ahead, I hear from you, and then I'm going to hear from Mr. Miller, and then we're going to go to lunch soon.
When this was going on, and you told me I had all those other options on what I could do in the pursuit of justice, I was aware of this process throughout, because I've invoked this process over the course of 20 years on more occasions than you're aware of. 3 of them have come up in this conversation. And I've known what the process was, and I've been validated in my right and my standing to bring this complaint. And then when it comes to double jeopardy, the statute says unless, the one that would preclude a subsequent prosecution for something that this man pled guilty to. And the unless is, are there different elements? So double jeopardy doesn't apply here. I mean, the very statute they rely on, if you take everything after unless, it fits chapter and verse with the distinct elements and the distinct actions required. So there is no double jeopardy. So now we're just at, why didn't I invoke some other process? Why did I come here and make you do your job? Well, because that's what the rule of court says. That's what my experience has been. That's what your experience has been. This is unprecedented for you. You've never been called to ask about standing in a case, and that's not one of the determinations. Your determination is there sufficient evidence to believe that probable cause exists? Did the offense occur within the territorial jurisdiction of this court? And did the offense occur within 7 years, because that's a statute of limitations? Anything you do beyond that is not your job.
That's not true. I don't believe that. I don't believe that. Because one thing is this. Sometimes the court rules are gray. They're gray. And so we have to then fight to look for some place to rest our thoughts. And so When I read this court rule, and the court rule as it relates to, you know, probable cause is rather thin. It doesn't give a lot. There's not a lot of case law or other things that kind of substantiate.
Say summons shall issue. Summons shall issue when these three things occur. That's right in the rule. The summons shall issue 1, 2, 3. Anything else is outside the four corners of that rule and is being read into it for this particular defendant. And I met that standard.
I'll let you be heard. I'll let you be heard, and I'll address you.
Your Honor, I don't want to belabor too much, but there's just a lot been said in the last 20 minutes, and I'm not going to belabor it too much. But I first want to make clear to the court that any reference to the media had to do with whether or not the motive here is pure in terms of the utilization of this statute for a citizen's complaint. And we cited to you cases, Leugman and Storm, that talk about a court can look at the motive of the complainant. On the issue of the application of 7:2-2, you asked the question in the context of tell me where, because let me preface this. It's apparent that Mr. Brennan wants to initiate this process and file his citizen's complaint because he's unhappy with the decision of the Chief Judge of the United States District Court who decided to impose this conviction, this penalty on Mr. Samson. He's unhappy with the fact that the United States Attorney made a decision in the plea agreement, and we cite this in our letter it appears at page 5. The United States agreed to, quote, not to, quote, initiate further criminal charges against David Samson for violations related to the use of his official position and authority as the chairman of the authority. He's not happy with the fact that local prosecutors may, given the notoriety of the case, may have chosen not to prosecute it. And he has his sense of duty, which in many respects displaces the entire bureaucracy of our criminal justice prosecutorial system, because Mr. Brennan believes that those things did not come, as the court rightly observed, did not come with the outcome that he wants. So the question is does a complainant with that agenda and with that motive satisfy? Is that you asked the standing question? Is that the kind of complainant that this rule and this statute contemplates? And what the court tells us in Leugman and tells us in Dennis in Storm, that's not the kind of complainant. And how do you? And now let's go back to the rule. It talks about a complaint, warrant, or summons charging any offense made by a private citizen. Now, it doesn't say. Because you asked the question, you said, he made the point. The prosecutor won't do it, therefore I can do it. But it doesn't say that the prosecutor can't do it. It doesn't say that the prosecutor won't do it. He had options. I mean, one option is on your ice cream story, where he uses his example of the observation of a rape or an observation of a robbery. Every citizen has a duty to report a crime. Mr. Brennan has chosen over 3 decades that his way of doing it is to not go to the local prosecutor. It's not to bring it to the attention of prosecutorial authorities with resources, whatever. But he's decided that his way of doing it is use the citizen complaint proceeding. God bless him, he's chose to do that, but now we know he's doing it in the context of something a little bit differently. It's not pure, and it's unfair for him to say, it's not fair of him to say it's pure in the sense of maybe his tradition.
He doesn't have any
Whoa, Mr. Brennan. Whoa, stop. I gave you ample opportunity.
Your Honor.
And now I'm giving him the opportunity.
He has no knowledge.
Whoa, Mr. Brennan.
Mr.
Brennan, you're being disrespectful.
I'm sorry.
Please.
Your Honor, all I'm saying is that we know that we can draw the dots. We know that he's a political candidate for office. And in fact, in Leugman, there's a suggestion that that's the very kind of person that this is not intended. But on the standing issue, you asked the question about remoteness from the event. He's presented to you an information, and he's presented you with a judgment of conviction. He's talked about the effect on him of the consequences of it, but he is certainly not privy to the facts and circumstances surrounding that conviction, the elements of that information and the like. He's not happy with the result, but that doesn't necessarily make him a victim. What we heard here today is he's unhappy with the result. The other point that I wanted to make, Your Honor, with respect to the application of 7:2-2, and this is true of all of this, use the term gray. Yes, it's gray, but there's something more fundamental here. We've cited to you the general rule that allows the court to relax rules in the interest of fairness and justice. Okay? That's a rule too, and that appears at the beginning of the rule book. And that rule has application here when combined with the body of law under
7:2-2.
well, that, not only that, but the body of law on, under a body that talks about fundamental fairness in the process. In a body, you might recall, there were succeeding indictments, 2 different trials. The question is whether the judge could dismiss the indictment, different facts, but the concepts in that case have application, and that is the whole question of fairness. So we are where we are. You're about to make a determination. I don't know whether you have or you haven't, but we're there, okay? And you're about to make a determination. You've been highly indulgent of both sides, and I highly respect the fact that you've been open to do that and to hear me out, and obviously you've heard out Mr. Brennan, but in the end, it's your call. You said that the first day that I showed up here. It's your call. And we're saying for all the reasons you mentioned, when you make that call, you have the authority to make that call, you have the power to make that call, you can apply fairness concepts to make that call, you can relax rules to make that call, and after you make it, I can't appeal it, and he can't appeal it. And the idea that he's twice suggested that a judge that made a call like that was subjected to discipline, I find is offensive not only to the bar, but offensive to the judiciary, and I want to go on the record of saying that.
Okay. So let me just say, let me just touch upon that last thing. I tell you this, I enjoy what I do. I believe that I was born and raised here in the city of Newark. Went to high school blocks away from here. I used to get off at a bus stop, public transportation, New Jersey Transit, just on the corner of Green Street and Broad Street. The bus stop no longer exists. But 14, 15, 16, 17 years old, I got off that bus stop and I walked up on William Street up the hill. Arts High School is where I went. It was High Street then, Martin Luther King now. So I never thought that I would have this great opportunity to serve my community in this way. I mean, particularly as I was standing at that bus stop, as the bus was going by, and I had just departed from it. I didn't think about that, just a half a block away from this courthouse. I never had the opportunity to even come into this courthouse until latter years. And so it's a great pleasure. It's a great pleasure to serve in this capacity. You've seen me on the record before I was dealing with your matter today, as well as on another occasion. I try to treat everybody with, as I say, dignity and respect. You've seen a couple of individuals walk to the front, and speak to me openly. I've given you information that people don't tend to have, just to go ahead and communicate while I was away. And certainly I had no concerns or issues sharing that information, and you used it in a respectful and professional way. And so I enjoy what I do. I enjoy what I do. I walk down the street oftentimes all the way around throughout downtown Newark as I'm, go to eat something or not, go up to the Whole Foods nowadays, and I see so many people I've dealt with in this court, so many individuals that I've even put in custody. And I have very civil conversations, and I tell people all the time, I'd rather see you on the street at a restaurant than in this court. And so those individuals who come before me on the video, or if they're chained up, come before me here, I treat them with the same dignity and respect that I would want to be treated with. So if I take a position or an action in court that is deemed against the grain, not in line with the more popular view and what have you. But I believe it's fair and just and right and reasonable. I'm willing to suffer the consequences. And if that means that I have to step away from this bench and perform some other task as an attorney or something else, I will be more than willing to do so. At the end of the day, I leave here knowing that I've done my best on every occasion. And so if for any reason I make a decision that causes either you or anybody in public on this occasion or some other matter to file any, anything against me, and so be it. And if my superiors determine that I'm not worthy to sit in this position, or that I'm suspended from practice, whatever the case may be, I'm willing to accept that consequence. I'm willing to accept that consequence. And if I do something wrong and I know that's wrong, then and I believe my mother did something wrong, she should suffer the consequence. So if I do something wrong, I gotta suffer the consequence. But if I do something that I believe is right and just, I'll take it just the same. Okay? So I say that whatever comes of this, it comes. Right? I'll still enjoy my boys, and if I have to get another job, even if it's an ice cream vendor, I'll do just that.
But Your Honor, the purpose of raising that issue was about the issue of standing, and had no, again, that's just his spin. But he raised Storm and Lloydman again, and he keeps raising them. And he's intentionally trying to mislead you into thinking they apply here. Storm and Lloydman deal with the ability of an individual to act as a private prosecutor. No prosecutor is attached to this proceeding now, and once you find probable cause, if you do so, my role ends in accordance with this. So Storm and Lloydman stand for the proposition. In Storm, he wanted to hire a prosecutor to take the case to trial, and Lloydman wanted to go before a grand jury. I mean, he's telling you that to try and confuse you and try and manipulate the court into thinking that those cases apply to probable cause determinations, and they don't. And you should be wary of an attorney who tries to manipulate you into thinking particular cases are applicable to things that they aren't. As we're sitting here, I can tell by the look on your face that you weren't fooled by that private prosecutor.
I say this. You know, what happens out there, you're both advocates for your position. And what happens out there is what happens out there every single day that I'm on the bench. And every judge sees the same thing. Now, I'm not coming to the bench depending on one argument or another. You know, I've pretty much made up my mind, some time ago. It's giving you all the opportunity to be heard, because that's what I believe you deserve in this particular instance, not in every instance, like, where there's a determination to be had. But I'm giving you all the opportunity, courtesy as I call it, informal, if you want to deem it that, right? And so I believe that individuals need to be heard, and I give people time, so long as it's reasonable. So I didn't want to extend this, for this amount of time. I didn't want to be here 3 times on this, nor did I want to come back from vacation, but you both, wanted to get this over with as soon as possible. So, I mean, I got hammered today,
Sorry.
No problem. I mean, I'm a big guy. I've dealt with these type of things before, right? And it just gives me pause to think, that I need another vacation now, But I think that the two of you, despite a couple of little things here and there, you're both gentlemen. I've learned a lot, and it's not usual that we have this type of a kind of play with arguments. And certainly both of you are great caliber in terms of your positions, and you both bring skills that I applaud. And so it's been although long for me, and although I'm quite I'm hungry at this time, I respect the fact that you both come today, and you've come in the past, and you've made your submissions, and you stand for what you stand for. So, Mr. Brennan, you may not practice law, but certainly, if I don't know what you do as a career, you put fireman in your email, so I take it that either you're a fireman or was a fireman, or you like firemen.
I'm retired.
Okay. But certainly, if you ever had an opportunity to be an advocate, you would be a great advocate.
Thank you.
Great advocate. And so, you say things today and last occasion that separate you and Mrs. Genova in terms of the quality of your position in the case, or I should say, in the quality of attorney. But even though you're not, I believe you told me before, you're not practicing, but and I said to you, you've done very well. We didn't shut you down. You've made ample arguments, strong arguments, at times convincing arguments, and you've done very well. So I don't know what you do with your life and your time, and I've learned a little more about you today and on the last occasion, but I still don't want to go and research you. Again, I'd rather research the tools my son needs for his little league games, right? Heart protector and all that other stuff like that. So anyhow, you should probably go back and take the bar if you haven't done that, and do your own thing. You're doing well, real well. Okay, so, and Mr. Genova, and I applaud you and thank you too for bringing that to the court. It's not very often that we see, a sitting partner of a firm that has the reputation and status of yours coming into court. But despite the fact that you're, well regarded, well recognized, I treat you just like I treat anybody else. Mr. Brennan, I treat you just like I treat anybody else. If there was somebody who had a 8th grade education that was here, I would treat you all the same. I treat you all the same. I'll give you any additional weight. And the names don't matter to me. It's just justice. And again, I believe in that. So, Mr. Genova, although I've given you, courtesies in terms of submissions and arguments and opportunities to be heard, my position still remains that the right to counsel comes after a determination for probable cause is had. And I wouldn't want to see attorney after attorney, trying to reach out to me, Judge, before you make a determination, let me be heard. I don't think that the system is prepared to do that. Certainly, that's why there's probable cause hearings that can be had after the fact. And so, Mr. Brennan, in terms of those things that you cited in the rule, certainly the rule cites what it cites, and you point out shall in various places. And I may mention that there's a certain gray in this area. I mean, if we looked at the rules just for municipal court, they're so thin. And if you look at the rules for criminal matters in Superior Court, they're probably 3 or 4 times as much or more. But as you look at each one individually, there's still a lot of gray. There's still so much gray. And Mr. Genova, certainly you're right. And I know, at the beginning of this book, it says just what you said, that when it's time for justice, you have to go ahead and apply those things, because each case can be quite different from the next, and certain things may need to be considered to come to justice, to come to a just position. And so I think I've done just that in giving all of you an opportunity to do exactly what you've been doing. On behalf of Mr. Samson, you've done that, Mr. Genova, and on behalf of the people of the state of New Jersey, Mr. Brennan, you've done that. You've come before this court to fight an injustice. And everything that you cited, Mr. Brennan, as it relates to the checklist, is there. But nonetheless, I still have an issue with staying. Now, other judges may not Other judges may not read that into the rule, but certainly I do. And so my position has been just so far removed, and counsel can make certain arguments, you know, about you and talk about your intent and what have you, but I don't look at any of those things. I simply look at what I would look at for any other person in this position. And so in this instance, I'm going to determine that there's no probable cause against him. Mr. Brennan can walk away if he wishes. I've been more than respectful to him, but he received a ruling that is against his desires, and instead of accepting that ruling, has simply gotten up and left. So that's unfortunate, again, because I praise him for his diligence, his efforts, and particularly his acumen as an advocate. So I take that not as a disrespect, certainly may be unsatisfied with my decision, but I nonetheless believe he's an excellent advocate, and an advocate for the people. So with that, Mr. Genova, I thank you for your time.
Thank you, Your Honor. Your Honor, may I have a request that I be accompanied by a sheriff's officer or police officer
Sure.
as I leave the building?
There's a couple of ways to exit the building. The more immediate one is here, but I'll ask the officer to escort you to your vehicle. You both came together.
Thank you.
Thank you. They'll escort you.
This way? This way?
Well, that was.
Oh, that was, yeah, let's go.
So, it'll be that one right there. So just give us a moment and, yeah. There we go.
Sure. I have a flight to catch.
Oh, you did? If I had known, I would have moved this along. I would have heard from you all less. It's open here. So, so if you just give us a moment. And so do you guys need anything? No? You good? You need anything? Okay, you good? So you go ahead. You go ahead. All right.
Thank you, officer.
Take care.
Enjoy your time back, Judge.
Well, I'll do my best. I tell you, I'm applying for another vacation. I need it.